Colin.
Hello, Clive.
We're back.
Indeed, absolutely right. Another podcast, another day, another podcast. I see you're still wearing the clothes you wore on the last one.
Colin, you're giving away our trade secrets already, aren't you? Do you remember the football manager, Brian Clough, Colin? He managed Nottingham Forest.
Yes.
I seem to remember years ago watching Grandstand, and they did an interview with him, and he had a wardrobe. He always used to wear, I think it was a green Umbro jumper with a red polo neck underneath. And I'm pretty sure when you opened his wardrobe, it was like a soldier's barracks, where you open the wardrobe and it's just full of identical clothes. And I'm pretty sure he had 6 or 7 of exactly the same thing. Anyway, Colin, if you open my wardrobe, it's the same. I have 6 of the same ties in case I have to work on a Saturday, 6 of the same jackets and 6 white shirts. So there we are.
Goodness me, it shows a remarkable lack of imagination.
It was the beauty of school, wasn't it, wearing a uniform, Colin? You never had to think about what you're going to wear.
No. Well, the beauty of my school was that you never had to think. But that's another story for another podcast.
There we go. Exactly. Yeah, Colin's school diaries, eh? Right. Anyway, today we are back with what we've called a Regal review, cases from the King's Bench Division. We haven't had a King's Bench Division for years, have we, Colin? People still call it the Queen's Bench Division. It's going to take some time to get around that. Queen's Counsel, King's Counsel, Queen's Bench Division, King's Bench Division. Anyway, these are cases from the King's Bench Division, which we hope will be of interest generally to criminal practitioners, but probably to people going to the magistrates' court and indeed the police station. There's a few bits and pieces in there for everyone there, and of course anyone who's going to the Crown Court. So we've got it's a bit of a mix and match as ever, because our agenda is dictated by cases that the King's Bench Division have decided. So we've got a little bit on identification, we've got a little bit on res gestae and abuse of process, but we've got a little bit on appeals from the Magistrates' Court to the Crown Court. Yeah, and 1 or 2 others. We've got 6 cases in total, Colin. But should we kick off with the first one on identification?
Okay.
First case is a case called Grier against the Director of Public Prosecutions. And as we've mentioned in other podcasts, there are show notes for all our podcasts. So if you're walking the dog, driving the car, or doing something else where you can't scribble anything down, don't worry, you can just click on the show notes and there is a hyperlink through to find all the cases, etc. So don't worry about writing anything down. And anything else of interest that we might mention during the podcast, we'll endeavour to include in the show notes to help you find all these resources at a later date. So this is a 2024 decision. We're here in 2025 recording this, so a relatively recent decision. And this was a case stated against the decision of a district judge. She was sitting at Reading Magistrates' Court, a magistrates' court with which you are overly familiar, I think, Colin.
Absolutely. My old stomping ground.
Yeah, your neck of the woods. Although Slough was probably your favourite. Slough and Bracknell, wasn't it? That's where we used to
Maidenhead Youth Court. I was the juvenile king.
Juvenile and Colin Beaumont are words that often appear in the same sentence, aren't they?
Carry on.
Anyway,
don't go there, Clive.
Anyway, this was a case, an issue about identification evidence and whether or not the issue of identification had been raised. I'll give a very brief précis of the facts, Colin. I'm not going to dwell on them. Police officer turns up on the forecourt of a petrol station. He sees some young lads, I think, in a car, probably looking a bit shifty, and carries out a check on them. And the car drives off, and he decides to try and pull the car over. And the car drives without due care and attention and fails to stop. And the car is found sometime later, and the police officer makes a note of all this, obviously doesn't apprehend a suspect at this stage. But what happens the next day, Colin, most criminal practitioners will probably be shouting at the podcast saying exactly what happened the next day. Somebody phoned the police station to see if they could recover their car. Now, usually what they do, Colin, although it didn't happen in this case, is they usually ring up and say, somebody stole my car, don't they? Or the old drink drive one, if you've been nicked for drinking, somebody stole my car, which is never a good idea, because a pervert in the course of justice counts usually gets added at that stage. But anyway, it was a general inquiry of I need to get my car back. Young man turns up at the police station, I think with his mum actually. Police Constable Price attends and sees him and says the person who was at the police station, I think it was Loddon Valley Police Station, was the same person I observed at the forecourt of the petrol station last night. Yes, it was dark and it was raining, but it was light underneath the canopy of the petrol station. And I observed him for about 15 seconds. I saw under the light. I arrested him at that stage. Goes into interview and goes no comment to all questions. And they say he's subsequently charged with those 2 offences. And they turn up to court. And for the first time, it is raised that on the PET form, the preparation for effective trial form, which we all have to fill out at the magistrate's courts if the defendant is pleading not guilty, the issues are that he's disputing being the driver and obviously as a result of that disputing his presence at the scene. So in other words, he is challenging the identification evidence of Police Constable Price. At trial, PC Price gave evidence, and interestingly, the case stated notice that it was never put to him in cross-examination that the defendant was not the driver of the Nissan motor vehicle, which is interesting. I just mentioned that as an aside. The defence made a submission of no case to answer and commented that the officer's notes had not been made soon enough. I think he started the notes that night and only finished the notes after he'd arrested the defendant, Mr. Grier, at the police station the next day. And issue was taken with that, and comment was made that the identification lacked detail, and of course the fact that there was no identification parade. District Judge rejected that submission. The defendant did not give evidence, and the District Judge, she went on to convict the defendant. The case stated the question posed for the consideration of the High Court, the Divisional Court, was this: was I right, asked the District Judge, not to exclude the identification evidence of Police Constable Price under Section 78 of the Police and Criminal Evidence Act of 1984. What did the Divisional Court say, Colin? Can you remember?
Something like it was very strange that there should be an argument that there was a breach of Code D of the Codes of Practice under PACE because of the failure of the police to hold identification procedures when the issue hadn't been flagged up at all at the police station stage by the suspect. And as I read the judgment, I thought, yeah, surely it's a little odd to be raising that at such a late stage, because if you go no comment, no comment, no comment, no comment, no comment, that's absolutely fine. I don't take issue with that. But surely somewhere you've got to put the police on notice if you want identification procedures, that identification is an issue in the case. That's just me. I would.
Yeah, quite. And the Court of Appeal have said previously, and I think the Divisional Court says in this case, that it is not a necessary inference that just because someone goes no comment, that they are therefore putting identification in issue, because a no-comment interview could hide a multitude of defences, namely, I was acting under duress. Secondly, I was the victim of modern slavery, for example. So it might be that you're not actually disputing the facts at all. So I think it's considered sometimes by the defence that because you go no comment and you're not admitting presence at the scene, participation in the incident, whatever it may be, that therefore says to the prosecution and in the shape of the police at that stage, I am disputing identification. And actually, as you say, Colin, you've got to actively dispute identification, haven't you? If it's not you, say so.
Is it too late, do you think, Clive, to stick it on the PET form in terms of setting up identification procedures? Because I think they put it on the PET form.
Yeah, they did. They did. I think that the challenge here, and what the High Court judge said, was this: that there's a difference at times, isn't there, between non-police witnesses, civilian witnesses, and police officers? Because, of course, the issue here was that PC Price, having arrested him, then obviously dealt with the case in terms of sitting in an interview room, processing him at the desk, at the custody desk, all those sorts of things, and had the greater advantage of having seen him for longer than 15 seconds. And you've mentioned Code of Practice, Code D, and the particular paragraph, isn't it? Is paragraph 3.12 in the Codes of Practice in relation to when an identification parade shall be held. The High Court judge said, the exceptions applied in this case, that there would be no benefit to holding an identification parade by that point because the officer had seen him for so long by that time. It'd just be redundant, wouldn't it? And any weight to be attached to the identification procedure would be meaningless. The defence would have simply said, well, you would have picked him out, wouldn't you, because you sat there in the police station with him for an hour or two or three.
Absolutely. Heads we win, tails you lose, I think is the expression, Clive.
Quite. So, were it, for example, to have been, a member of staff at the petrol station who had observed him, and then not been the police officer who had met him at the police station the next day, then absolutely there may well have been value in saying, well, let's carry on our identification procedure. And he's only seen him for 15 seconds. Let's see whether it was a fleeting glance, or let's see whether it was better than that. Let's test the reliability of his identification. They refer to three cases. I mean, obviously Forbes is the big case, isn't it? So in terms of, when I teach on identification evidence, there are what I refer to as the twin pillars in identification cases, aren't there, Colin? Of course, Turnbull, the Lord Widgery judgment back in 1976, and they're giving all that guidance on identification evidence. And then, of course, we have the case of Forbes, the 2000 case from the House of Lords, in which Lord Bingham gave the lead judgment. And it's a very forthright and straightforward judgment, isn't it, in saying that, that the Code of Practice itself is an intensely practical document, and it is not old-fashioned literalism to read and do what the Code of Practice says, namely to hold an identification parade. If there was a genuine issue, this shouldn't be a judgment call for the officer whether to hold it. This is this is a mandatory requirement. This is a defendant's prima facie right at times to have an identification parade. And so, as a police station representative, Colin, if you'd known that Police Constable Price was identifying your client and your client was putting identification in issue, would you have said anything about that at the police station?
I might have been concerned about him being the interviewing officer.
Quite.
And looking at my client over a long period of time. Can we have someone else?
Yes. Yeah, quite. Quite. Yeah, he's no longer the investigator, so he's a witness to all of this, isn't he?
Of course he is.
Yeah.
He's the chief witness.
Quite. The Crown's case stands and falls based on his evidence, doesn't it?
There's a danger that the interview might become unseemly. It was you. It wasn't. It was. I saw you.
Or he pulls his hoodie up over his head for the whole interview, for example. Yeah.
Quite.
Yeah. But yeah, there are a couple of, obviously Forbes was referred to as the big case, and a couple of others, and they found that one of them was an old case, and of course the latest version of the Code of Practice, I think, was issued back in 2017, and one of the judgments was given under an old version of the code, and then two of the other cases they found weren't, despite counsel's arguments, I think, at the Divisional Court, were not on all fours. So the High Court judge said, for the obligation to be considered, namely to hold an identification parade, at the very least, the suspect must dispute identity. As it says, they are a suspect at the police station, aren't they? You must put identification in issue at an early stage. And what they said is effectively, it will be a fact-specific decision for the court to make. There's no hard and fast rule that in these circumstances you must hold one, in another one you mustn't. It will depend on the facts. And it won't be necessary for a formal or even an express statement to be made. It could be an implied statement. So, for example, if you put in a pre-prepared statement saying, I did not commit the burglary or that robbery, I was not the person that was seen running away, then by implication you're putting identification in issue, aren't you?
Or you could mention it at charge.
Yes. And they said, for example, that the case put forward by Mr. Grier could have been inconsistent with him being the person. So we mentioned, half jokingly, half serious earlier, the drink drive one where you ring up and say, oh, my car's been stolen, or, just my car's been stolen generally. Of course, if Mr. Grier in this case had phoned the police and said, my car was stolen last night at 5 o'clock, for example, and it was 7 o'clock when Police Constable Price saw him at the petrol station, then by implication, Mr. Grier would be saying, it couldn't have been me who was driving the car at the time, therefore identification was in issue. But that's not what Mr. Grier had said in this case, was it? Simply, I need to arrange to get my car back, please. Dispute could even be put in before arrest or interview. When you're being chased by the police, just as they stop you and slap the handcuffs on you, saying, what are you arresting me for? I haven't done anything wrong. You could do it at that very, very early stage, hadn't you? And indeed, the Divisional Court said that the defendant had every opportunity, but he said nothing until his appearance at court. Important case. Important guidance for everyone, be it at the police station or at court. Next case, case 2, Colin, we're going to talk about is the issue of bail. Bail. And this is a case of W, X, Y, and Z against Croydon Crown Court. Defendants have been anonymised because there is a trial outstanding, so we won't say too much about the facts, just to stick to exactly what's mentioned in the judgment. It is an issue in relation to bail rather than any substantive issue dealing with the trial at all. This was a judicial review of a decision to refuse bail at Croydon Crown Court. And we don't get many of these anymore, do we, Colin? We don't get many bail decisions being challenged by the defence in the High Court anymore, do we? The reason is, of course, is the Criminal Justice Act 2003 took away the defendant's right to appeal to a High Court judge for bail, didn't it?
It preserved it for the prosecution.
Well, no, it didn't preserve it. It gave it to the prosecution, Colin. I don't think they had it before.
I thought that prior to the 2003 Act that both parties had it, but it was taken away from the defence.
From the defence, yeah. So the only way as the defence you can get yourself in front of a High Court judge these days is by way of judicial review, isn't it? So the Bail Amendment Act of 1993 deals with prosecution appeals, doesn't it, to a High Court judge?
My understanding now is that if you're pursuing a matter that has to go to the High Court, like JR or case stated, and your client just happens to be in custody, then of course you can put in an application for bail to the single judge. But if you're not going anywhere near the High Court because it's not judicial review and it's not case stated, once upon a time you had the right to, as it were, appeal the matter to a High Court judge with a view to granting you bail. But the Criminal Justice Act 2003 took that away as a right from the defence.
Yeah, absolutely. It's a good judgment generally to read. And what I say, particularly if there are any students listening to this, is it provides a really good review in relation to the law of bail. It doesn't just plough into the decision itself. So it starts off by talking about Article 5, of course, of the European Convention on Human Rights, about the liberty and security of the person. And then, of course, it turns to the Bail Act of 1976 and talks about the right to bail and the presumption in favour of bail. All the defendants in this case of good character, because that's an important point to bear in mind in the decision. And then it reminds us the case of ex parte Dean, that a bail decision should only be amended if there's been a material change in circumstances. And that counts for both sides, doesn't it, Colin, in terms of a judge withdrawing bail from a defendant, or indeed a defendant being granted bail having been remanded in custody, that decision should only really be amended if there has been a material change in circumstances.
Yes, and of course the Lord Chief has reminded us in the latest set of criminal practice directions that if a person has been on bail throughout, there is no need to revisit the matter simply because the trial has started.
Was that the Lord Chief or the Lady Chief Justice, Colin?
Oh, forgive me, yes. Yes, forgive me.
Smack wrist, Colin.
Right, indeed. I shall be defrocked at this rate.
Steady. So, in relation to the background, the complainant in this case had reported to her college mentors that she was to be married in Pakistan, and the college had given her some assistance seemingly, and then she'd arranged to enter a refuge, but sadly she didn't arrive in time, but with the help of the college she found a hotel room for that night instead, and her boyfriend of 3 years took her to that hotel room. When she was settled at the hotel room, he left her, and in the early hours of the morning there was some banging on her hotel room door. Rather than open the door, she immediately called her boyfriend and put him on FaceTime so he could video. It was a video call so he could see what was going on. And 3 of her 4 brothers and her sister-in-law were apparently said to be standing outside the hotel room door, and she was said to have been forced from the room and out of the hotel to the family home. And the hotel CCTV seemingly covered some of this incident. At the family home, her phone was examined, and as a result of text messages on there, she was called a whore by her brothers, and she was alleged to have been assaulted by W, X and Z, 3 of the defendants, with one of them using a screwdriver as a weapon. She managed to secrete her mobile phone and call police whilst she was in the bathroom, and the 4 defendants were all arrested at the property, and there were knives and chains found at the property, and there was also evidence of flights having been booked to Pakistan for this arranged marriage, where it was said she was to be married to her cousin. That's enough of the background. In terms of what happened at trial, there were various issues and the trial was adjourned. I'll cut to the chase, the important part, because the trial having commenced and the evidence of the complainant having been led, Section 28 was used to cross-examine the complainant. So most practitioners will know Section 28 of the Youth Justice and Criminal Evidence Act 1999 allows the courts to pre-record cross-examination, so that then evidence in chief was most probably conducted by way of an ABE interview, in this case, an achieving best evidence interview. She would then have been cross-examined in court by defence counsel, and that would have been recorded under Section 28 of the Youth Justice and Criminal Evidence Act. And following that, there were arguments at trial about disclosure, which caused the initial trial to collapse and be relisted 9 months later. Following the collapse of the trial, all defendants made detailed applications for bail, and the Crown opposed bail against all 4 defendants on the 3 main grounds, namely failure to surrender, commission of further offences and interference with witnesses. In terms of the reasons for refusing bail, the bail application was heard by the trial judge, who obviously had considerable experience of the case by this time. And the reasons from the judge were relatively cursory, and we'll see what else the Divisional Court had to say about them in the end. He talked about having considered the case carefully. He commented that he was, of course, very familiar with the case. He was mindful of the fact that all defendants were of good character. However, he observed that these were serious charges of honour-based kidnap, and he said, bearing in mind the facts, the evidence and the circumstances, they left him with substantial grounds to believe that the Crown's 3 objections were all made out. So that was the decision which was being challenged before the High Court. The law was reviewed on it in relation to judicial review, of course, generally being on Wednesbury unreasonable grounds. Lord Justice Maurice Kay was quoted in a previous case where he said it was not limited, appeals against or reviews against bail decisions such as this were not limited to only rare cases where a judge had gone wrong in an extreme way. They then go through and review more recent guidance in a case I know you're familiar with, Colin, case of Iqbal against Canterbury Crown Court, where a defendant, I think, had been on bail for some time, and then having been charged, I think he was then remanded in custody at his first appearance. And Mrs. Justice Carr, as she then was, gave some detailed guidance in relation to this, talked about the fact that the court had weighted his attendance and compliance in the balance, but it was suggested that his bail application had been dismissed without proper reasons. However, Mrs. Justice Carr, as she then was, said that the judge's analysis was tailor-made, clear and reasoned. And I think those are 3 really nice words to bear in mind when giving decisions in relation to bail or when considering bail, that any decision must be tailor-made and the reasons must be clear and reasoned. And I think the Divisional Court would say that the reasons were somewhat lacking in the case of X, Y, WX, Y and Z. The reason, of course, that this application was made for bail at this stage was because the defence said there had been a significant change in circumstances. Defence counsel put it rather nicely, I have to say. He said that the evidence of the complainant, because it had now been given and she'd been cross-examined, her evidence was effectively locked in. So in relation to, of course, one of the Crown's objections to bail in relation to interference with witnesses, then that objection couldn't really be substantiated anymore, because what was there to interfere with? The complainant had given her evidence, and as he rightly observed, it was now locked in and couldn't be changed. The Divisional Court held that there was an absence of adequate reasons in this case, and just because the judge was well versed in this case, it did not absolve him of his public law requirements to explain why the defendants were unsuccessful. And I think the Sir Peter Lane, I think it was, giving judgment, said this quite succinctly. He said his conclusions were just that. They were conclusions devoid of any proper explanation. So there we are, Colin. We see this occasionally, don't we? You know, experienced Crown Court judges giving decisions in relation to bail. And I'm not criticising any judge for a moment, because it's a difficult and stressful job. But the High Court said that there was a complete lack of explanation for his decision.
Yes, I remember reading a case some years ago in which the judge was taken to the High Court because he had not simply said, "There are substantial grounds to believe." And on that basis alone, would you believe, the High Court found that the judicial review was appropriate and that those words must always be used. So the High Court, they are fond, aren't they, of forensically examining exactly what took place on a bail decision.
Yeah. And I have to say, Colin, in other areas of the law, the Divisional Court and probably the Court of Appeal too are not quite as forensic. But we started off, didn't we, by talking about Article 5. And it's not hyperbole to talk about the liberty of the subject, that when it comes to bail decisions, there is almost this heightened examination, isn't there, Colin? Because the liberty of the subject is so fundamental that if we are going to take away someone's bail or we're going to restrict their liberty in some way, we have to be very clear about why we're doing it, about how we're doing it, and give those explanations. And it's often the case, isn't it, Colin? You read lots of cases, as do I, that you look at a decision and you think, well, on the face of it, the decision wasn't wrong, but there are just no reasons to back it up. And I think judges probably get quite annoyed because they think of it and thought, well, there were lots of reasons I could have given for coming to this decision. And the Divisional Court just saying, well, you should have done that. We see this with sentence appeals, don't we, Colin? That sometimes the Court of Appeal has to conduct, a process of deductive reasoning where they have to work out what the starting point was that the judge must have taken based on the guidelines, then factor in what credit they must have given, and then work out whether or not the sentence was manifestly excessive or not. And quite often they might say, well, look, the judge didn't give appropriate reasons or to give adequate reasons, but working it out for ourselves, the sentence was entirely within the range. And so often the criticism isn't about the outcome, it's about the manner in which they got to the outcome, isn't it? This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come complete with notes. We've been doing this now since June 2020 on topics as diverse as
the Magistrates Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode.
Right, so there we are. Important, I say, not to simply take bail decisions as routine. They are anything but routine, aren't they? They must be tailor-made, clear and reasoned in terms of those decisions. And that's the point. I mean, I don't know how that bail decision ended, Colin. It may well have gone back to the Crown Court, probably gone in front of a different judge, and the judge may have come to a similar decision in terms of refusing bail, but having given reasons on this occasion.
Yes.
Who knows? Case number 3, Colin. We've got a case on zombie knives, and we were talking about this recently. Well, Colin, you like this case, don't you? Thompson against the CPS. This is a 2024 case.
Yeah, I do. I do like this case. This was, the words on the blade. I think it was the blade or what. Rambo, First Blood.
First Blood. Before we dive in, Colin, I was disappointed, and I put it no higher than that. I was disappointed that the district judge took judicial notice of what Rambo was. In fact, I didn't even realise that Rambo was both a novel and a film. I thought they were just films. But there we are, both a novel and a film. The judge took judicial notice of what Rambo was, and Sylvester Stallone was not called to give evidence at the hearing, Colin. Disappointing.
There you are.
Go on, tell us more, Colin. Dive into the order.
In relation to the Offensive Weapons Order of 1988, of course, and that order is constantly being updated, isn't it? The very latest editions we've got are zombie-style knives and zombie-style machetes. And as far as those are concerned, there need be no words on the handle or the blade. But for zombie knives, there must be the words on the handle or blade suggestive of violence. And so it really was a simple interpretation, wasn't it, by the district judge as to whether or not he was prepared to say, yes, Rambo First Blood, that'll do for me, in terms of those words being suggestive of violence. And it's a classic case, really, isn't it, of why you would go to the High Court rather than the Crown Court. No point in going to the Crown Court. You need that particular judgment call tested, and you test it, of course, by going to the High Court. And the High Court said, yes, we agree with the district judge. Rambo First Blood, that'll do for us. That's a zombie knife.
Well, there'd been an incident, hadn't there? Mr. Thompson's family home, I think, involving his mother, and he was arrested for possession of this knife, a bit of criminal damage, and threats to kill against his mother. I think he pleaded to the criminal damage, and I think his mother didn't attend at trial sometime later, so the threats to kill, the Crown offered no evidence, and he accepted, didn't he, being in possession of this knife. But in terms of that order, as you say, there are three aspects, aren't there, you have to prove in relation to it being a zombie knife. It needs to have a cutting edge, doesn't it, Colin, and a serrated edge. So these are literally double-edged knives, aren't they? Double-edged sword. And then there must be images or words on the blade or handle that suggest it's to be used for the purpose of violence. And he accepted the first two bits, but the dispute was over the artistic merits of the film Rambo to an extent, wasn't it, Colin?
Yes, quite, absolutely. If you're going to have a zombie-style knife or a zombie knife under your bed, make sure the words on the handle read something like, solely for the cutting of courgettes. Then you'll be fine.
Yeah. But, and sometimes people use the word Rambo knife, a Rambo-style knife, and that was part of the argument that the word Rambo had entered the vernacular and the dictionary definition was referred to. But it was a 9-inch blade, wasn't it, Colin? And the handle could be unscrewed. It had a compass, a fishing line, and a match in it. It was quite clearly a survival-style knife, wasn't it?
Yes, quite, absolutely. Eat your heart out, Bear Grylls.
Yeah, well, you can imagine John Rambo being holed up in the woods for a week or two, catching fish, lighting fires, sustaining himself on nature.
It may come to all of us, Clive, sooner or later. It may. Have you looked at the footsie recently?
Yeah, don't start on that, Colin.
Press on. Next case.
Well, hang on. I was going to mention one point that I thought I might make, Colin. Of course, the district judge and the High Court took judicial notice of what Rambo was, and they talked about the dictionary definition of Rambo. And of course, there is another route to admissibility which wasn't mentioned in either the Magistrates' Court or the Divisional Court. Namely, of course, dictionaries are admissible under Section 118 of the Criminal Justice Act 2003, aren't they? It was an example of hearsay evidence. So, whilst there was some discussion here, and there was argument before the Divisional Court as to whether or not the judge was entitled to take judicial notice, or whether or not more evidence needed to have been led, the dictionary definition is admissible under Section 118, or at least that's my view. I don't know about you.
Well, yes, I'd have to revisit Section 118, the old raised gesti reputation, and see if dictionaries are there.
I think dictionaries, maps, matters of public record, all those things, they're included under 118.
Yeah. Ordnance survey maps, yeah.
Yeah, there we are. I thought I'd mention that point before we leave, Colin. There we go. Good. Right. Case 4, Colin, absent witnesses, res gestae evidence, the case of DPP and Barton. Many people may be familiar with this case, not only legally, but it's one that's received a little bit of attention in the press. Many people will be familiar with the fact that Joey Barton is a former Premiership footballer and has been a football manager in more recent years. And back in, I think it was 2021 now, he was alleged to have assaulted his wife at a house in Kew in southwest London. And police were called, weren't they, Colin? And the police attended, and Mrs. Barton was seen with injuries about her person, but she never provided a witness statement to the police. and the Crown's case proceeded on the basis of the evidence of the police officers and body-worn video footage, etc., and the injuries. They decided not to call Mrs. Barton to give evidence, and the defence made an application to stay the case as an abuse of process, and the district judge at Wimbledon Magistrates Court, I think, was eventually persuaded to stay the case as an abuse of process. Of course, the prosecution didn't like that, so off to the divisional court they went, and the divisional court had a little bit to say about this, didn't they, Colin?
I think I'm right. If memory serves me well, I think I'm right in saying that clearly they hadn't ever taken a formal statement from her. As far as the Crown were concerned, she was never going to be a witness. The whole of their evidence was going to effectively be raised gesti, the 999 call, the statements caught on the body cam footage, plus, of course, the evidence from the officers as to her injuries. And I think the district judge said, well, look, clearly statements had been made that were caught on the body cam footage, but some while afterwards she'd gone to the police station and sought to retract those earlier statements. And so surely we were dealing here with inconsistent statements. And how could the defence possibly be afforded a fair trial if they weren't able to cross-examine her on those inconsistent statements? I hope I'm right in thinking that that was the main thrust of the argument, really, as to why the district judge considered that on those facts, it probably was an abusive process. And as you say, off to the High Court, and the High Court ruled that no, it really wasn't an abusive process. There was nothing wrong, obviously, with the evidence consisting solely of hearsay. And they also mentioned, didn't they, that if the Crown were not going to call her as a witness, there'd be nothing wrong with the court itself calling her as a witness. And of course, once she was a witness, she could be cross-examined by the defence, and then that would solve, the mischief arising out of not being called as a witness.
And practically, Colin, I think she was actually there at court, wasn't she? Physically there.
More than once.
So it wasn't as if yes. So it wouldn't be as if they needed to adjourn it to go and find her.
No, but the Crown's view was we are not calling her as a witness, and they stood their ground.
Yeah, that's that. We don't intend to call her. And of course, we know, don't we, Colin? And these are mentioned in the case of Barton. We've had a series of cases, and we've had cases such as Ibrahim, Barnaby, Morgan, which have all said there's nothing wrong with the Crown proceeding on the basis they don't intend to call a witness who could appear on behalf of the prosecution in circumstances where they have not given a signed statement to the court. We know, the House of Lords said previously, haven't we, that the res gesti doctrine should not be used as a device to avoid calling the witness. But they said in circumstances where matters are of a domestic nature, where the witness may be in fear and there may be risk of repercussions. This is, this is the prosecution just acknowledging the reality of the position that were they to be called to give evidence, then they would suffer the physical consequences potentially in the future. So this wasn't them using the res gesti doctrine as a device to avoid calling the maker of the statement. And of course, where they have made a statement and their evidence is consistent with that, then no problem there. And I think what's new about Barton, the point you're making, Colin, quite rightly there, is that this was an issue where the defence said, well, hang on, these cases are different to Ibrahim, Barnaby and Morgan, because in those situations, the complainant has always been consistent. So there's been very little to cross-examine the complainant on other than lie, this didn't happen. Whereas here, actually the credibility of the complainant is in question because they've said one thing in the evidence the Crown are relying on, and they've said something else in other evidence. Yes. And of course, the hearsay provisions allow for that evidence to be admitted still, don't they, Colin? The witness doesn't have to be called for that evidence to be put to them. And we see this in cases of, of vulnerability now with witnesses, don't we, where sometimes defence counsel are absolved of the requirement to put their case to a witness. You might have inconsistent evidence, but you don't have to cross-examine, or in fact, I'm not going to allow you to cross-examine this witness on it. So there's nothing new in this in terms of the trial process. This has been happening for 15 years or so, maybe more, where there has been evidence of a witness that's been inconsistent, and actually judges have said, no, you can't put that inconsistency to them. You can comment on it later in your speech, but there's no requirement for you to put that to the witness for them to comment.
And the old res gestae point, of course, is that, well, that was a common law exception whereby hearsay statements were admissible, and all of those common law exceptions have been retained by Section 118 of the Criminal Justice Act 2003, of which res gestae is simply a classic. And we've got the Supreme Court in the case of Horncastle saying there's nothing wrong with a conviction based solely on hearsay, so long as the judge ensures that the trial is fair. And we've got the European Court of Human Rights, Al-Khawaja and Tahira, saying the same thing.
Yeah.
So the principle is well established.
Yeah. Should say, Colin, this is in contradistinction to cases where the prosecution do have a Section 9 statement from the complainant. And we've got, haven't we, the case of Wills from 2016. I think all of these cases are mentioned in the case of Barton, aren't they? So you can find the references there. And Wills was rather different, wasn't it? I think Wills, there were two defendants, and one was the stepfather and one was the stepbrother of the complainant. And an incident having happened, I think they were both charged with common assault. And an incident had taken place and they were charged with common assault. And the complainant, the stepdaughter and stepsister, had given a Section 9 statement to the police. Of course, very different to Ibrahim, Barnaby and Morgan. What happened then, as you'll remember, Colin, is on the day of trial, the complainant didn't attend. And so the Crown went away to try and find out what had happened, took instructions, and their instructions were to proceed with the trial and adduce her evidence, or seek to adduce her evidence, under the res gestae principles. The magistrate succeeded to that application and went on to convict both Wills. They went off to the divisional court, and the divisional court said no. They said the fact you had a witness statement and you intended to call the complainant, your failure to make inquiries as to where she was and why she wasn't at court was fatal to your res gestae application. You can't use the res gestae doctrine to rescue you from your failure to get your witness to court, especially when everybody thinks that your witness is coming to court. You've got a Section 9 statement and they're going to be there and give evidence.
Absolutely.
And I think that's an important distinction, Colin. And I know when the case of Wills initially came out, I remember teaching and training then, and a lot of prosecutors were saying, do you know what, we're having real difficulty post-Wills getting res gestae evidence in now. Everyone's saying, no, you need to get the witness to court. And I think, if I may be so bold as to say, that that's based on a misreading and a misunderstanding of Wills. You've got to consider that in these situations, there are two different starting points. And if there are different starting points, the finishing point may well be different. In Ibrahim, Barnaby and Morgan, and in Barton, there's no witness or no witness statement from the witness. There's no Section 9 statement, and the prosecution has never been undertaken on the basis that the Crown are going to get the complainant to court, call them to give evidence, and they are going to be available for cross-examination. That's very different to the case of Wills, where it was always prosecuted on the basis that we've got a statement, the complainant will come to court, she will give evidence, and she will be cross-examined. That's the basis, that's the expectation with which that trial was going to take place. So I think the starting points are really important, because the finishing points may be different for different reasons. Can I mention, just before we leave, absent witnesses and res gestae, the case of Morgan. This is a line for the prosecutors amongst you. My first advocacy tutor at bar school always said to me, Colin, he said, the first rule of advocacy, he said, is steal everything. He said, if there's a line, a phrase, a technique, a tactic, a way of doing something, he said, steal it, borrow it and use it. And there's a great line in a case of Morgan. The High Court judge said that he was unimpressed about the defence's submission about the complainant not being very precise in her evidence when she initially gave her account to the police at the scene. And the High Court judge said, one would not expect a complainant in a distressed state to deal with the matter in forensic detail. Now, as a prosecutor, if you're not using that in your closing speech in the magistrate's court, the next time you have a witness who doesn't come up to proof, then I don't know what you're doing.
Why aren't you?
Exactly.
Moving on.
Good. Moving on. Last couple of cases, Colin. We've got a case of, I'm not sure actually about the pronunciation, Kasurian against the CPS. This was a case that I have some sympathy with the defendant. It seems like he spent more time in court in recent years than I have, because he was initially convicted at the City of London Magistrates Court. The case, he was acquitted, in fact, and then it went on a case stay to the Divisional Court. And then it came back to the magistrates' court with a direction to convict. They did convict him,
Yes.
and then he tried to appeal the conviction to the Crown Court. The Crown Court being, of course, the Old Bailey, the Central Criminal Court, and went in front of the Recorder of London, of course, a very senior judge. Then had to go on appeal again, or judicial review, to the Divisional Court. So, in fact, I only ever appeared in the Divisional Court once. So this defendant's been in the Divisional Court more times than I have, Colin.
As in, did you have a right of appeal where you had only been convicted, the court having referred back with a direction to convict? What an interesting scenario.
Well, quite, and it wasn't just any old court either, Colin. But the Lord Chief Justice was presiding as well. So it's a bold advocate, isn't it, who treks off to down Old Bailey and says to the Recorder of London that the Lord Chief got it wrong. But there we are. That's what we're there to do.
My view would be it's still a conviction in the magistrate's court, and surely the normal appeal rules apply.
Yeah, I think that's effectively what the Divisional Court said, wasn't it? So the defendant had been convicted of aggravated trespass. He dug a tunnel to obstruct High Speed 2 being built, and it cost them, Colin, believe it or not, £195,000 to extract 3 protesters from the tunnels which they built. There's something like a team called the Confined Spaces team or something who were brought in to get them out. So anyway, they were convicted. So the district judge initially, I think it might have been a deputy district judge, actually found him not guilty in the mag. So off to the Divisional Court they went. Back they came with a direction from the Lord Chief to convict. They did convict, and he said, well, I want to appeal this to the Crown Court. And off he went. So of course, as we know, Colin, you can appeal, can't you, and a conviction or a sentence to the Crown Court under Section 108 of the Magistrates' Court Act 1980. Interestingly, of course, you can only appeal your conviction if you were convicted. So if you pleaded guilty, you cannot appeal your conviction. Just an interesting aside on that, Colin. You'll be familiar, of course, with the post office scandal, as will all listeners to this podcast. And so, of course, many people were convicted in the magistrates' court, and the way in which their convictions were overturned was by way of an appeal to the Crown Court. But of course, you're looking at Section 108 right now and thinking, well, hang on, they pleaded guilty, they can't appeal. And what was happening is they were going to the Crown Court, and they were allowed to vacate their plea by the Crown Court judge, enter a not guilty plea, and then I think the Crown were offering no evidence. I think that was the procedure by which they got round that part of Section 108. So it actually has caused a few problems, the fact that you can't appeal despite having pleaded guilty. So there we go. Yes, as you say, off they went to the Divisional Court, and the Divisional Court said, yes, you do still have an avenue of appeal, don't you, Colin? I think it's Section 111(4) that they were arguing about under the Magistrates' Court Act, and the Divisional Court said no. They said you can still appeal even where there's been a direction to convict from the Divisional Court.
Which, although I'm not a betting man, had you posed that question to me as a lawyer, I probably would have said, no, you can't appeal. There you are.
Yeah.
Just shows how I am.
What do we know, Colin? Well, they say about lawyers, Colin, we don't get old, we just lose our appeal.
I'm not. 4 lawyers in a room, 5 opinions, eh?
Quite. Only 5. Last case, Colin. Judicial review to remove a caution in the case of Puri, P-U-R-I, against the Chief Constable of Thames Valley. We're back in the Thames Valley. We started in the Thames Valley, Colin. We're finishing in the Thames Valley.
We are. And I would say if you're going to advise a client at the police station to accept a caution, that's absolutely fine, but just make sure you're aware of the list of things you should be telling this person before they accept the caution. Because if they do accept the caution, it is hellishly difficult to ever get a caution removed from the record. I think your starting point is probably writing to the old superintendent of that particular police station, and if you get no joy, you're off to the High Court. It's not easy.
Mr. Pure had accepted a caution for a bit of cannabis handing in the police station, Colin. I think a few years later he'd applied, I think it was to be a chess coach, and he had to disclose this, and he realised that it had then barred him from that job. He hadn't got the job because of this caution that he'd accepted. And he said, well, had I known that it would have stopped me doing this in the future, I never would have accepted the caution at the police station. So attempted to reopen the issue, and unsurprisingly, the Divisional Court said his solicitor had no independent recollection of being at the police station some years earlier and advising him, but his usual custom was to have advised somebody that, if you accept this, it will have consequences for you, you'll have to disclose it, all those sorts of things. And equally, on the other hand, they said, that the fairness to the police of, asking a police officer some years later to come to court then and give evidence and say exactly what they told the suspect at the time when they accepted the caution. And just as an aside, Colin, there's an interesting case on bad character called Olu from 2010, which I'll put in the show notes as well. This was a case at Reading Crown Court. We're very Thames Valley heavy in this one, aren't we, Colin? But at Reading Crown Court, where defendants' caution for possession of a bladed article had gone before the jury in his murder trial, and the murder, of course, involved the use of a knife. So hence why the Crown said this was relevant. And Lord Justice Thomas, as he then was, of course, went on to be the Lord Chief Justice, said, that the courts would be closing their minds to the obvious were they to consider there is a wealth of difference between a defendant or a suspect, as they are then, accepting a caution without legal advice and accepting one with. And of course, Olu makes the point that, of course, just because you've accepted the caution, it's not automatically evidence of your guilt of that offence. So you can seek a trial, for example, where Mr. Olu being tried, he could seek to rebut that caution and say, well, I accepted it for various reasons, so just to get me out of the police station at the time. I didn't realise the consequence it would have, all those sorts of things. But there is a difference, I think, if ever you're arguing this point, about a caution accepted in circumstances where a defendant was represented at the police station or a suspect was represented at the police station, and circumstances where they were not. So there we are. Case of Olu, good one to be aware of in relation to bad character, Colin.
Excellent.
There we are. A Regal review, Colin. 6 cases, a bonus case of 7. So there we are. I hope everyone's enjoyed that. Hope that's been interesting. Hope there's been something for everybody. And hope to see you again on the next podcast.
Thank you, Clive.
Thanks, Colin.
Well, thank you for tuning in to this particular edition of the Legal Eagle podcast. We do hope that you've enjoyed it. You can find further episodes on our website, legal-eagle-training.com. On behalf of myself and Clive, thank you. Say goodbye, Clive.
Goodbye, Clive.